Hello. Hello, hello. Hello, we are here for the live session. We want to take questions. Let us know in the comments how are you, how you feeling this lovely Sunday, late evening. We want to take questions about parole in place for spouses of U.S. citizens. A lawsuit is pending. We don't know how this is going to turn out, but we just want to take case. We are taking cases because until further notice, the parole in place program is still going on. So there's nothing as far as stopping it. There's no court order stopping it. Okay. So we want to talk about what do you need. Yeah, if you got here, say hi in the comment. Let me know if you have a question. Say hi in the comment. Let me know if you have a question. We're filing applications even today. I was just talking to a few people. We just filed a couple applications today. So I'm still here. You can email me if you need your application to be filed. Hi, how are you? Olankule Jempeji. Oh my gosh, Olankule Jempeji. No, just wait. There's nothing I'll do. Those are the same thing we do is we contact the congressman office, ombudsman office. You should do that, and then just wait. USCIS eventually they will answer your question. They will process your application. Yeah. If you need a lawsuit, you should get a lawyer who's licensed in federal court in your state where the case is pending. So you have to look at this USCIS center location where the case is pending. That's where you file a lawsuit, and the lawyer has to be licensed in that federal court. Because I'm licensed in federal court here in Baltimore and in Washington D.C. So yeah, let's see. We have questions here. Let's see. Hold on. Let me try to show it. Okay. Can someone on VAWA working authorization parole travel to Saudi Arabia? If a person wants to travel, they have to have a parole, right? If parole is granted, then they can travel. Now, depending on the country where they're going, whether the country requires a visa, then you have to do your own research to know whether in Saudi Arabia their embassy requires a visa before entering their country. So you have to know that. You can't just book a flight and go. You don't know what are the requirements in the other country as far as visa is concerned. How do you get there? But if you have a parole, already granted, yes, you can travel, provided that you don't have any like asylum pending somewhere, right? So that's the answer to that question. Anybody else? Yeah, I'm still gonna be talking about parole in place. We're gonna do thanks. You're welcome. You're welcome. I'm still gonna be talking about parole in place. We're gonna do a case assessment, quick case assessment, and see. Outcome. Let's see the case assessment here. Yeah, the first question you ask yourself is, how long have you been in the United States? If it's more than 10 years, then that's already, you met the requirement, 10 years or more. Now the second question is, how did you enter the United States? If you enter with a visa, then you are not eligible. And another way to know too is to look at your notice to appear. If it says admitted, inspected, or parole, then you are not eligible for this new Biden policy. Then since your initial entry into the United States, have you left and re-enter? Because we want to maintain the 10 years physical presence, continuous physical presence, right? But they say that if you left briefly, then you might still qualify, depending depending on how you left and you came back. But remember that when it comes to adjustment of status, if you left and came back again without permission, entry without inspection, then again you do not meet the requirement, because now you have a permanent bar. So those are the things we go basically when a person schedule a consultation. Those are the things we're going to ask as questions, right? Have you ever been ordered removed, and then you left and you came back without inspection? Again, that's a permanent bar. Are you legally married to a U.S. citizen as of June 17, 2024? Because remember, it's based on marriage. And if you're married to a U.S. citizen as of June 17, 2024, do you have minor children who are undocumented as well? As far as children are concerned, the children do not have to meet the 10 years requirement. Basically, they can still apply even if the parent did not meet the 10 years requirement. Okay. What else? Because I have to look at the validity of marriage too, right? If you were married before, do you have a divorce decree to show that the first marriage was already terminated? If your other partner was married before, they have a divorce decree to show that the marriage in question was also terminated. If you have common law marriage, if your jurisdiction recognizes it as a marriage, then yes, you can still, let's say if you have common law marriage, and let's say you live in Maryland, and the state of Maryland recognize that as a valid marriage, then yes, you can still apply. If your spouse is deceased, but were you married as of June 17, 2024? So let's say you got married and your spouse died. So long as you did not get remarried, then yes, you still uh, to apply for this parole. But then the question becomes, was your I-130 filed before your spouse's death, or an I-360 petition within 2 years of your spouse's death? Let's see. To be eligible, you can be approved for parole, but later on, to be eligible to adjust status, then you have to ask yourself a question: was my I-130 filed before my spouse was before my spouse passed away? Okay. If not, then you are not going to be eligible for adjustment of status anyway. If you have an I-136 petition, then if you have I-360 petition, really you don't need this parole, because our self-petitioner can adjust status regardless, right, of entry without inspection or with inspection. So do you have biological children without immigration status? Yeah, we talked about your children too can adjust if they're unmarried, under the age of 21, and by the time you guys got married, the stepchild was under the age of 18. That's how you consider a stepchild. So what else? Then we go into criminal records, right? Have you ever been arrested, charged with any crime, been given a citation or a ticket, questioned by a police for any crime or legal violations? Okay. Even if the charge were dismissed, dropped, you were not found guilty, you have to explain that, describe it, and provide evidence to corroborate with what you're saying, right? So if you've been convicted, then you go any of this disqualifying crime, any felony, you are not qualified for this. Murder, torture, rape, sexual abuse, you will not be qualified for this. Offenses involving firearms, explosive material, if offenses relating to espionage, slavery, involuntary servitude, human trafficking, aggravated assault, child pornography, domestic violence, stalking, child abuse, child neglect, child abandonment. This really just shows that you lack good moral and character if you have those type of offenses, and most of them are what is considered violent crime, and some of them are crime involving moral turpitude, and basically a threat to national security. Yeah, that will disqualify a person. So, but for other crime, then you might overcome it. For example, you might overcome a presumption of being not eligible by showing that why the government should exercise discretion on your favor. That's when the lawyer come into play, right? That they're gonna explain as to why. So let's say, for example, at the time you were convicted, you were a minor, or basically you're gonna show those other things that were involved into it. Maybe you were discharged, or the offenses got lessered. So Do you have your administrative procedure closed? If it's closed, basically if you have a case closed, administratively closed, yes, you can still be able to apply for parole, but you have to really show a lot of things. If you are in removal, let's say you have removal order, been granted voluntary departure, never left, administrative closure, case still pending with USCIS, sorry, with immigration court, then you have to show a lot of things to overcome the presumption of ineligibility. Okay. So what else? Then we go to the document, right? Certificate of marriage to show that you've been in a valid marriage. Your proof of identity, proof of U.S. spouse citizenship. If you've been arrested, arrest record and court disposition for any arrest, charges, or convictions. To establish continuous physical presence in the United States for the past 10 years. Then we go with rent receipt, employment records, utility bills, school records, hospital and medical records, money order receipt, official record from a religious entity, birth certificate of children, bank statement, all that. So if you want to show basically that they have to really exercise discretion on your behalf, I usually suggest that people basically show their tax return to show good moral character, that they pay their taxes, community tie, birth certificate. It shows that you have ties in the U.S. if your children were born here. If you have people with mental disability, your job certificate. So a lot of things that shows that it's good for this government, either for humanitarian reasons or for public government interests. Those are the elements that we need in order to file for you and make an argument. Okay. Yeah, let's see what else. Yeah, that'll be all, right, as far as case assessment is concerned. Can you change the status from asylum to student? I think it's pretty much not possible in terms of you can be a student but on your asylum status, but to go back to your F1 visa status is not going to work because of overstayed visa. In order to change your status within the US, you have to be within lawful status. Yeah, the answer is technically no. And NAD 9 ICE. The answer will be no. I don't think it's possible. Okay, so let's see. We have question here. Okay, if a Canadian citizen travel to America, is he automatically American citizen? No. Why will Canadian become automatically an American citizen? No. They have to go through the process of eligibility. We still have to know why are they eligible, based on what? Marriage, residency, military, what? No, the answer is no, Hakim. Hello, Huri, how are you? Yeah, we're still here talking about parole in place for spouses of US citizens, trying to elaborate more on the requirements and how to make a good case so that you can get approved. Yeah, so I don't have anything else besides talking about it. So If a person has a question, they just have to put it in the comment so we can answer those questions. And just know that the lawsuit is still ongoing. We don't know what's gonna happen, but we hope nothing bad happens. That's why we encourage people to file when the program is still valid. Yeah, tomorrow is Monday. We might get a lot of updates. Hi, sir. How are you? Long time. How's your case going? Did you win your cancellation of removal case? I know I don't forget people who comment a lot. I remember their cases in my head, really. So, how is it going on? Trying to print out those paper. Oh, you have your master hearing in June 2025. Oh, okay. That's next year. Yeah, it's just that the immigration court takes forever. But at least you have a court date. So that's what you need, a court date. Go to your master hearing, then you go to your actual hearing. I don't see questions. Okay, if anybody has a question, just put it in the comment. We already talked about parole in place, the requirements, how to make a good case, a valid case, and right now, you know, the lawsuit is still pending, so we're encouraging people to apply because we don't want them to be stuck like DACA applicants who never got their DACA. So everything should be okay except for the extreme hardship factor. Okay, my daughter's wife expecting for child. Oh, okay. Yeah, everything combined, right? You just have to have the totality of circumstances, right? Then your lawyer probably gonna argue about extreme hardship if they look at it in totality, you know. So yeah, just gather more evidence. Yeah, 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 that's just a normal routine, right? You do the fingerprint and then you wait for your master hearing, and then you go to the master hearing. That's when they take pleadings. Then you go. I'm pretty sure you know all that because you've been already to those hearing before. So yeah, then the actual individual hearing, that's when they're gonna argue for you. Totality of circumstances is basically what is gonna help you on your case. Totality of all the things going on. How about I terminate my case in my master hearing? Can I? No! You have to be granted cancellation. If they terminate, how are you going to adjust? Based on what? You have to say no. Because they're going to say they want to dismiss it, no priority. But you have to say no, because if they dismiss or terminate, you have nothing. Because that's the only defense, cancellation of removal. Otherwise, you're just going to wait until your child turns 21. Unless you want to wait, right? You go to the hearing, they terminate removal, then you wait until the child is going to turn 21. Then you apply under your child's petitions for you. So if you want to wait, then that would be the best option. But if you want to fight for cancellation, then you have to go to the individual hearing so that you can argue your case. Right? Otherwise, if they terminate, you're going to adjust based on what? Nothing. You don't have any reason. In order to adjust status, you have to have an underlying petition that allows you to adjust status. It's pretty much the way I divide it, it's pretty much 3 categories, right? I would say 4 categories. We have family-based, immediate family member. That's when we talk about spouses, children when they're 21, or older, or parents when they are petitioning for younger children. Then you have the second category, employment-based. By employment, you know if you overstay, you're out of it. Then we have humanitarian, when a person gets granted, let's say, a VAWA petition, a T visa, a U visa, asylum, if it's granted. And then we have self-petitions or investment. But when it comes to employment, everything that has to do with employment, you have to be within lawful status, unless you have the 245I, which I talked about a long time ago. Okay, if you were in Kentucky, you'd be rich by now, because I will have to get client already. But just send them my videos. They might hire me even from far away. You need to send them my videos. Why you don't send them so they can schedule a consultation? Especially for parole. I don't need to be there. Parole is being filed online. Yeah, you said no if you want to fight for the case. If you say yes, then basically you just gonna have to say yes. If you say yes, it means that you agree to just wait until your child turns 21. That's what it means. No. No, they're gonna issue a final decision based on what? You have to. The burden is on you to prove that you are eligible for cancellation of removal. So you have to argue the case and submit evidence. The judge is just not going to make a decision based on what? Yeah, it doesn't work like that. You know those things, right? You've been to immigration court before. Please, you work only for immigration? Yes. Only immigration matters. Miyukiwa 06. Yeah, so I'm only doing immigration law. Basically, well, immigration is just like a lot by itself, right? So it has 4 components. We have family, humanitarian, those are asylum cases. Then we have investment, Then we have, you know, employment. So yeah, only anything that has to do with immigration, okay? I'm not doing anything. I try to do family law with divorce, but lot of people. Yeah, we'll fight to the end. Okay, college professor. Yeah, at least it shows that you basically what it shows, that the way I'll see it is basically that if you already have a job here, uh, going back home, you're not gonna have the same opportunity, you know, and your children pretty much are not gonna have the same opportunity because the way maybe the salary that you will get there compared to the salary that you're getting here to support your children is not going to help your children be able to support your children. That's how people, you know, they make those type of arguments. So um, yes, SA, you need to yeah, you need to do yeah, you need to send me those clients. They need to schedule consultation, talk to me, especially for those parole. Yeah. Canadian visa, no. I'm here in America. I don't do Canadian immigration. Unless a Canadian person wants to immigrate to the US. That's a different story, right? What is the average time for a decision after AOS interview? Average, I'll give it 6 months as an average time. But once you went to the interview, you just have to file inquiry online. After 30 days, start filing inquiry online to, to follow up, because those people will be sitting on your case forever. You're welcome. Who else is talking? Yeah, after 30 days, you need to just file an inquiry. If you don't hear from them, keep filing inquiry online after 30 days. Every 30 days, you keep doing it until they get tired of your inquiry. They're just going to respond. Because if you just sit, basically, they'll be sitting on your case forever, especially here in Baltimore. You're in Chicago, right? But in Baltimore, forget that. After interview, you will wait for them and nobody's gonna respond. You just have to get out of your way to get a response. It's like, sometimes I wonder, like, really, are you serious? Oh, Milwaukee. Yeah, I've never dealt with Milwaukee. I don't know how things go there. But, you know, just after I-130, just um, Yeah, just keep following up. How long does I-130 take? I don't know. Really, I don't know. You really just have to go online and look at the processing time. It can take from 12 months to 3 years to 2 years. Uh, yeah. Can you top that in your case? 25 years of waiting. Oh Lord. Yeah, but since you have like the how do you call it? You have like this patience. Like you have like you get like a trophy, like an award for patience, right? The word patience means like you. If they look at patience, they know it's hurry. You get there because you're almost there. Like you waited a quarter of a century, now you're there. So I don't think there's much you can do at this point, but wait, you get it. How long has it been since you've been since you've been waiting for after the interview? Has it been like 6 months yet? And by the way, you need to try your congressman as well, right? You try your congressman. Did you try your congressman? Or are you just waiting? You're welcome. Anyway, so what else we have to talk about? Let's see the I-130 processing time because everybody's asking for it. Process. Yeah, let me check the processing time because everybody's just waiting for it. I-130 processing time. Okay, U.S. citizen spouse, right? If we're talking about U.S. citizen spouse, let's see. National Benefit Center, they say 44 months. Wow, now it's 4 years? Really? That's too long. All Service Center, 15 months and a half. Old field offices, 62 months. Wow, that's too long. Those I-130 is just gonna end up in lawsuit. I was telling my client we're just gonna file a lawsuit because I don't think we're gonna find a solution. Or not just a couple of weeks. Anyway, after 30 days, just really just file an inquiry. Yeah, online. Thank you, thank you, thank you, welcome. Anyway, so I guess we don't have any more questions. We answer all questions. If you want, you can go back if you want to learn more about this parole in place for spouses of U.S. citizens. If you know a person who might qualify for it, just let us know. Because even today I was working on those cases. Then I thought maybe I should come back and do this live session. Okay. I'm pretty sure tomorrow we'll have another update on this lawsuit. I'll come back here to talk about it. But other than that, until next time, bye-bye.